Hello, everybody. Today is Wednesday, May 28th, 2025, and welcome to the Consumer Warranty Workshop. This is a guide to understanding your rights under California and federal law. And this presentation is given by the Public Law Center and is funded through a generous grant by the Rose Foundation for Communities and the Environment. So a few housekeeping items before we begin. Using the Zoom platform, you can have this meeting translated into your preferred language by using the closed captioning option. Right now it's set to translate into Spanish, so you should be seeing a Spanish translation on the bottom of your screen. If you'd like to change the language, you can go to the closed captioning button. It probably says CC, and then click the up caret button and select the language to which you want the captions translated. When you registered for this webinar, you filled in a survey, and at the end of the webinar, you'll be given a chance to fill in another survey. And this is a way for us to see how you liked the presentation and whether or not we're teaching you the things that we hope to teach you. So please take the survey that pops up at the end of the meeting. And by the way, I should have said this first, this meeting is being recorded. The recording will be available after the meeting and will be posted to our Public Law Center's YouTube site. And also the templates that we refer to throughout the workshop will be emailed to everyone who has registered. And if you haven't registered and you're on here today and you would like to get a copy of the templates, please be sure to email us at cww@publiclawcenter.org. So let's get started. Here's a brief introduction to warranty law. The warranties that we're going to talk about today are warranties that are governed by both California and by the federal laws. Using a warranty under the laws we're going to discuss today, you can demand that a seller or a manufacturer either repair, replace, or refund your product. And why is this important? It's important because it helps us as consumers enforce our rights. It also protects consumers from defective products, and warranties are essential for ensuring that manufacturers uphold product quality. And finally, warranties can stop us from discarding products and overloading our landfills and the landfills of other countries where we send our trash. This is especially important when it comes to consumer electronics that may contain toxic chemicals that seep into the ground and into the groundwater. It's important that we try to recycle as much as possible, and that's why repair or refund or replace are very important. So there are two basic types of warranties in the warranty world. Whoops. There are express warranties and there are implied warranties. Now, express warranties are written or verbal guarantees that are created either by the seller or the manufacturer. In addition to the warranties that we're used to, the ones that come along with the package that you buy, express warranties also might be signs that are posted at the place of purchase. For instance, you're at Best Buy and there's a sign that says, for the month of May, there's an extra 30-day warranty on every cell phone that you purchase. That's an express warranty that can be enforced. It also may include statements made by salespeople before or after the sale. And it also can include models or samples that are shown before or at the time of sale. All of these things can create express warranties in the eyes of the law. Now, we also have something called implied warranties. And implied warranties are warranties that apply whether or not there's an express warranty given. These are just by law, certain implied warranties come along with every purchase that somebody makes. There are two very specific ones that we're going to talk about today. One is called the warranty of merchantability, and that means that the product that you buy is going to be the product that you expect. So, for instance, if you purchase a vacuum cleaner, the vacuum cleaner is going to work for the ordinary purpose of a vacuum cleaner. It's going to suck the dirt up off your floor. If you buy a toaster, your toaster is going to toast bread. You know, that's the basic thing. It's going to be of average quality. An implied warranty of merchantability doesn't mean it's going to be some super duper product, but it just means it's going to be an average product that does what you expect it to do, and it's going to be properly packaged and labeled. Um, the warranty of fitness for a particular purpose only comes into play if you have engaged the salesperson in some kind of discussion where you say to the salesperson, I need a product, let's say a stapler. I need a stapler that will staple through 150 pages. And the salesman says, this stapler is going to do the job, and you buy that stapler. You now have a warranty of fitness for a particular purpose that can be enforced by law. This often happens when it comes to cell phones, when it comes to things like vacuum cleaners or other products where you might go in to say, look, I need a product that does XYZ, and you don't really personally know which of the many products sitting on the shelves will do that job for you. And so you rely on the salesperson to guide you to the right product. That makes a warranty that is enforceable against that salesperson and the store where you purchased it. Because if the salesperson says this product will do this, then the product better do that. Otherwise, you can enforce your warranty under law. Now, an implied warranty can be disclaimed if the product is being sold as is. So I'm sure everyone has had the experience of purchasing a used car, or they know people who've purchased a used car, and the sales document has, in big words, as is sale. That means there's no warranty on it, neither an express warranty nor an implied warranty. That is really the only time that an implied warranty can be disclaimed. If there's an express warranty on the product, implied warranties cannot be disclaimed. So obviously, if there's an express warranty, it's not an as-is sale, because an as-is sale means no warranties. If there's an express warranty, implied warranties come into play. If it doesn't say anything about a warranty and doesn't say the words as is, implied warranties come into play as a matter of law. There we go. So the two big warranty laws that we're going to talk about today are the California Lemon Law and the Magnuson Moss Warranty Act, which is a federal law. And both of these apply to purchases made in California. So the California Lemon Law is a state law that's also known as the Song-Beverly Act, S-O-N-G Beverly Act. People generally call it the lemon law, and the code sections are right there on the screen. The California lemon law and the Magnuson Moss Warranty Act work together, and you can bring claims under both of these in state court. You don't have to go to federal court. And we're going to explain to you how to enforce both of these. We're going to give you a very simple method for forcing a seller and or a manufacturer to provide the warranty service that they're required to under law. So California lemon law, I'm probably going to call it Song-Beverly or Lemon Law. Magnuson Moss Warranty Act, I'll probably refer to it at Mag Moss. Let's go over the California Lemon Law first. So many people know the California Lemon Law as applying to cars. There are millions of advertisements out there with people talking about bringing lawsuits against usually used car dealers or not, new car dealers for lemon law claims, and we think of lemon law as being for cars. But the lemon law in California is not just for cars. It applies to all consumer goods except for food and clothing that are sold at retail in California. And what's a consumer good? A consumer good is a product that is purchased primarily for personal, family, or household purposes. So really what you have to consider is the fact that if you're purchasing something for use in your business, It is likely not going to be covered under the California lemon law, but if you're purchasing something for your personal use, such as a vacuum cleaner, toaster, cell phone, car, any of these things that are sold at retail are going to be covered by the California lemon law. So what does the California lemon law do? It requires that a manufacturer or a seller refund or replace a warranty product if they can't repair it within a reasonable number of attempts. So usually the customer must deliver the product to an in-state repair facility within the warranty period, and in-state repair facilities must be available if a seller or manufacturer is selling a product at retail in California. Now, it doesn't mean that in-state repair facilities must be available forever. How long an in-state repair facility must be available to a consumer depends on the wholesale price of a product. So for products with a wholesale price of under $99.99, there must be an in-state repair facility available for 3 years after the date of manufacture. And for goods with a wholesale price of $100 or more, there must be an in-state repair facility available for a period of 7 years. Now, this is the California law. I don't know what the law is in other states, so make sure that you check your law before you go ahead and look for an in-state repair facility. The other thing the California lemon law does is it allows a private right of action, so that if the seller or manufacturer does not comply with the lemon law, does not repair, replace, or refund your defective product, then you can bring them to court and you can sue them under California's lemon law, and you can ask the judge to reimburse you for any of your expenses for having to bring them to court. So oftentimes, because the expenses, including attorney's fees, could be reimbursed, you may be able to get an attorney to take on these cases for free, but you also are probably capable of taking these cases yourself to court. It's not some special trick. The California court websites have really wonderful self-help resources to help people that are not represented by attorneys to bring cases to enforce their rights on their own. I'll explain more about that later. So let's get right to it. How do you enforce your rights under the California lemon law? So step one, you want to confirm that your product is covered under the lemon law. So remember, it must have been sold with a warranty. It must have been purchased in California. I don't have on this page, but remember, it must be a consumer good, not food, not clothing, but it must be a consumer good. And the product must have a defect. And let's talk for a second about the defect. The defect must substantially impair the product's use, value, or safety. So what does that mean? That means that if you have a defect in a product, it's not perfect. Like, for instance, you went and purchased a cell phone, and the cell phone has a, I'm not going to say a crack in the screen because that would impair the product's use, value, or safety. But let's say the cell phone has a little scratch on the side, and you just purchased it and you spend $1,000 on the cell phone and there's a scratch, and you're not happy about the fact that there's a scratch. Well, you'd have to question whether or not the defect substantially impairs the product's use, value, or safety. I would argue that a little scratch on the side of your cell phone does not substantially impair the product's use, value, or safety. So you are likely not going to prevail in a lemon law case with respect to that scratch. Now, however, if you purchase a product and there's a crack, you purchase a cell phone and there's a crack right down this middle of the screen, now you've got a defect that substantially impairs the product's use, right? You can't really see what's going on under the crack. It impairs the value because everyone knows that if you try to resell a cell phone that has a cracked screen, you're going to get less money than if you resell a cell phone that doesn't have a cracked screen. And safety. I don't know how many of you have tried to rub your finger on a cell phone when there's a cracked screen, but you could really hurt yourself. You could cut your finger. So, a cracked cell phone screen is a defect that substantially impairs the product's use, value, or safety and is likely to be covered by the Lemon Law. So, step two. So, first, you determine that the defect is one that's covered under the Lemon Law. Step two, you're going to make what's called under law a reasonable number of repair attempts. Now, reasonable doesn't say how many. Does that mean one repair attempt, two repair attempts, three repair attempts? It doesn't say. So that's usually for the judge to decide. Under the circumstances, did you try to get it repaired a reasonable number of times? If you look at cases where judges have considered lemon law, it looks to us like between 2 and 3 is considered reasonable with respect to repair attempts. Now, if you've got a product that's very unwieldy, let's say a refrigerator, and you can't keep bringing it back and forth to the repair facility, the judge might consider that one repair attempt is sufficient. Remember earlier I said that you're required to bring it to an in-state repair facility to have it to let them try to repair it. But there's an exception in the law for products that you really can't move. You know, you might be in a situation where you can't get this refrigerator moved to a repair facility. And under those circumstances, that requirement may be waived. If a car is not functioning, you know, you would have to get it repaired. You'd have to get it towed to a repair facility in order to get it there. So under those circumstances, the judge might consider one repair attempt is sufficient. So reasonable repair attempts is decided by the judge, but in general, two repair attempts is usually good. 3 is better. One if it's a product that's difficult to bring to a repair center to get repaired. So one thing that we always recommend that you do is you document every time you try to get your product repaired, because if you later have to bring a lawsuit for either refund or a full replacement of the product because they were unable to repair, you want to be able to say first to the manufacturer and then to the judge, if necessary, I tried to get it repaired 3 times or 2 times. Here's the dates. Here's where I went. Here's what they said. So I recommend that you document every visit, put it in your calendar, put it in a notes app on your cell phone, write it down on a piece of paper that you save. These are good enough proofs when you go to enforce your rights under the Lemon Law. So step 3 is you want to gather evidence for your claim. And the best piece of evidence that you have are these documents that I just told you to save. Save a list of when you brought the product in for repair. That's proof that you tried to repair the product. You also should keep records of the actual warranty if you have a copy of it. You should keep records of anything that you're given by the repair shop, such as repair orders or receipts that acknowledge that you brought the product in there for repair, talks about what the problem is, talks about what they did. Those are excellent pieces of evidence for your claim. You want to keep track of any communications that you had with the seller or the manufacturer. So for instance, let's go back to my cell phone. Let's say you open the box and there's a scratch on it and you immediately call Best Buy to say, hey, there's a scratch on this phone. I spent $1,000. I don't want it. I want a replacement. And you're going to write down, spoke to Best Buy today, May 28th, 2025, explained to them about the scratch on my cell phone. They said, whatever, come and bring it back. Never mind, we're not going to replace it for a scratch. Whatever it is they said, you write it down. If you then send an email to the manufacturer, keep a copy of that email. If you send a message to the manufacturer on their website, make sure you do a screenshot or a photograph of that message that you're sending to the manufacturer, because oftentimes when you fill in a complaint form on a manufacturer's website, it's not there's no way for you to keep a copy, and they don't always send you a copy. I wish to say that they do always send you a copy, but a lot of times they don't. So I always either do a print screen or I copy and paste what I'm sending in as my complaint, and I write down the date that I made the complaint, and I use that as proof if I have to go to court on a lemon law claim later. And now the one other piece of evidence that you could do, it's not necessary, um, is take a picture or a video of the defect in the product. So let's go back to the vacuum cleaner. If your vacuum cleaner is not picking up the dirt off your floor, have somebody take a video of you trying to clean up some dirt and showing that the vacuum cleaner is not working. That's great evidence that would be really helpful to use in court when you're trying to assert your rights. So let's go to the fourth step. The fourth step is you want to notify the manufacturer and or the seller in writing. I would always do both at the same time. You're writing the letter anyway, you might as well write one to the seller and one to the manufacturer. And of course, the seller is the store where you purchase the product, and the manufacturer is the entity that manufactured the product. And you know where the store is because you went there to buy it, and you can find the manufacturer's address either on the actual written warranty that came with your product, or you could certainly find it online nowadays. So you're going to notify the manufacturer and seller in writing. Well, how do you do that? We've made it very easy for you. We've provided templates, and two different templates under the Song-Beverly Act. One that's going to go to the seller and one that's going to go to the manufacturer. And in these templates, you're going to explain to the seller or the manufacturer or both what exactly the problem was, what steps you took to resolve it, and what you want to have happen. Do you want the product replaced, or do you just want your money back? One thing that I must say is that some sellers and manufacturers require you to participate in arbitration before they will either refund you or replace your product. This is allowed. They're allowed to require you to participate in arbitration, but they are not allowed to make you pay anything for it. And the arbitration is not binding. So what does that mean? Arbitration is where you and the other side go to what's called a third party neutral. That means someone that doesn't have skin in the game. So it's not someone that wants you to win, and it's not someone that wants the other side to win. It's somebody that's neutral. So you go, and when I say go, it could certainly be over a Zoom call just like this usually is. It's very rare nowadays that you'd have to actually travel somewhere to do an arbitration on a lemon law case. But if they require it, they're going to explain to you exactly what you have to do. So if you have to if they require you to participate, you have to do it. And so you will explain to the third party neutral what happened with your product. The other side will explain why they think they don't have to repair or replace it, and the third party neutral will make a decision, agreeing with you, agreeing with the other side, or somehow splitting the baby, as they say. They agree with you on some things, they agree with the other side on other things. Now, whatever the arbitrator says, you do not have to accept it. So if the arbitrator says, you, consumer, do not have a claim, go away, fine, the arbitrator can say that, but you still have your rights under the lemon law. You can still bring the manufacturer or the seller to court with a lawsuit under the lemon law. Now, an arbitration that doesn't go in your favor is going to be good evidence for the other side, but that doesn't mean that you're going to lose. Maybe the arbitrator didn't properly understand what was going on. Maybe you didn't have all your proofs with you. It doesn't matter what happened. You don't have to pay for it, and you don't have to accept it as the final word. You can still go to court on your lemon law claim. So some sellers and manufacturers won't require you to do arbitration, depending really on the price of the product. Like some products, maybe a product that costs only about $50 to $100, it's probably not going to be worth it for the seller or the manufacturer to pay for arbitration if all you want is a refund. But if you've got a product that's like a cell phone that's over $1,000, or certainly a car, they are likely to require you to arbitrate. But that's okay. That's not the end of the road for you. Don't even worry. So what I included here is is the sample template letter that you're going to send to the seller or the manufacturer after you've already tried to get the product repaired. So remember, the steps are for lemon law. Number one, you determine that your product is covered under the warranty. Number two, you try to have the product repaired. And if they don't repair it, you're going to send a letter to the seller and the manufacturer to say, I bought this product, here's my receipt, it's defective, here's what's wrong with it, and here's what I tried to do to repair it. No matter what I've tried, it's not repairable. Therefore, I would like you to either repair or replace this product. You give them a deadline by which they have to respond to you, and then we see what they're going to do. So this is exactly the templated letter that's going to be included in the handouts, or that you can request from us. Again, CWW, that stands for Consumer Warranty Workshop, cww@publiclawcenter.org, and we're happy to send you these templates. This template is in English. We also have them in some other languages. So the places that are highlighted in yellow are the places that you are going to fill in. So you can see in the beginning, it has your name, your address, city, state, zip, and your email. You change the date of the letter. We want you to send these letters by certified mail. The reason is because it provides proof, number one, that you sent it, and proof, number two, that they received it. And that's really good proof to bring to court with you if you end up having to go to court. And all you do is follow along and fill in the parts that are in yellow. The little table is where you're going to show the number of times that you tried to bring the product in for repair. You could delete some of the lines if you didn't bring it 4 times. Easily, one or two or three lines is certainly sufficient. And you're going to give them a date, probably about 30 days from the day you send the letter. And you say, I want you to get back to me within 30 days. And if you don't get back to me within 30 days, then I reserve my right to go ahead and sue you. You don't have to write any of this language down. Everything is in the letter for you, and it's all going to be included in your packet. So if after you send that letter and you wait those 30 days or however many days you wrote in the letter, and they do not provide a refund or replacement, at that point, your only choice is to file a lawsuit. You could certainly try to contact the seller or manufacturer one more time, but if they haven't responded the first time, the likelihood is that they're not going to respond to your second inquiry. You can try it if you want, but you can go right ahead and file a lawsuit. So this is not as hard as it seems, filing a lawsuit. Like I said earlier in the presentation, the California websites have a self-help section that is excellent, and it explains to you how you can file a lawsuit on your own without an attorney. And these lawsuits are really just one-issue lawsuits. You're going to just write down, I purchased this product on certain date. The product was defective. Here's why. I tried to get it repaired. Here's the number of times and where I brought it and what they said. Then I wrote a letter to the seller and the manufacturer, and neither of them would repair and replace. This is a breach of my rights under the California lemon law, and therefore I want repair or replacement. At that point, you probably just want your money back. So you can say, I just want my money back, and I also want to be reimbursed for all of the expenses that I incurred in bringing this lawsuit. So that would include filing fees, if there are any, fees to serve the other side, mailing fees, costs for you to take the product to the in-state repair facility. Maybe you had to drive there, maybe you had to ship it there. All of these costs get added in, and you're going to say to the judge, I not only want to be refunded for the amount of money I spent on this product, but I want to be made whole. I want the seller or manufacturer to reimburse me for all of my costs, because they did not cover the warranty. Um, Small claims court in California is very easy and does not require any special type of language. It's for products that are up to $12,500. So most of the products that we're talking about here, you can bring a claim in small claims court in California. You don't even have to type a lawsuit in small claims in California. You can write it out by hand. Um, and again, the California self-help websites are really helpful so that you can enforce your rights without using a lawyer. Now, again, because attorney's fees can get reimbursed, it's possible that you find a lawyer who's going to take on a lemon law case because they can get their attorney's fees reimbursed. So it's not really a big risk for them. If they think you have a good case, if they think that the lemon law applies, then chances are their attorney's fees are going to get reimbursed at the same time that you are going to get a refund for your product. So that's California's lemon law. Do we have any questions? I forgot to tell you that there's a Q&A that you can drop your questions in. Let me take a look and see if there's anything. Nope, there's no questions there. So to the right of your screen, there should be a box that says Q&A. Feel free to drop questions in there and I'll address them as we continue with the presentation. So, oops, let me just, there we go. So now let's move on to the Magnuson Moss Warranty Act. Remember, the Magnuson Moss Warranty Act is the federal law that governs warranties. And even though it's a federal law, we can use it in California. So the Mag Moss Warranty Act is a federal law that regulates, simplifies, and standardizes consumer warranties. And Mag Moss applies not only to express and implied warranties, it also applies to service contracts in general. So a lot of times nowadays, if you buy a product, particularly a high ticket item like a cell phone or even cars, the seller or the manufacturer offers you a service contract on top of the regular warranty that's given with the product. Excuse me one second. That would be something that is paid for on top of the product. So it's usually offered by a third party. The seller or the manufacturer says, do you want to spend X dollars a month for an additional warranty? And you could either say yes or no. But if you say yes, that additional warranty or service contract is governed by the MAGMOS Federal Warranty Act. So MAGMOS says that if a manufacturer or seller gives you an express warranty, the warranty has to meet certain standards and contain certain disclosures. And it sharply restricts the ability of a seller or manufacturer to disclaim the implied warranties. And of course, MAGMOS also applies for attorney's fees and actual damages for breach of the warranty. So it's another good law to use to try and get an attorney to take on your case because they have now two shots, lemon law and MAGMOS, to try and get their attorney's fees reimbursed. So here are the rules under MAGMOS. There are three basic rules that you should know. A warranty that is provided when you purchase a product, it must be clearly disclosed, and it must indicate whether the warranty is full or limited. It must have one of those two words, full warranty or limited warranty. If the warranty must also be stated in a single, clear, and easy to read document. So the seller or the manufacturer cannot require you to visit multiple websites to find out the terms of the warranty. They can't give you multiple documents that talk about the warranty. There must be all the warranty information in one document that's clear and easy to read. That means that anyone should be able to understand it. It doesn't require a lawyer to understand the language. And the warranty document must be available at the time of purchase, not afterwards. they can't give it to you after the fact. You want to know what you're purchasing, including the terms of the warranty at the time of purchase. And those things are required under the Magnuson Warranty Act. So here are the prohibitions. Here are the things that MagMoss prohibits. So if a full warranty is sold with a product, it is absolutely illegal to try to disclaim any of the implied warranties. So they can't do it. It's a violation of MagMoss. The only thing that they can do is that if a limited warranty is sold with your product, remember I said that under MagMoss, the seller or the manufacturer is required to say whether a warranty is full or limited. So if it's full, they cannot disclaim or modify any of the implied warranties. But if the warranty is limited, they can modify the implied warranties in one way. They can match the duration of the limited warranty. So let's say you purchase a product that has a limited warranty of 6 months. The manufacturer is allowed then to also limit the implied warranties to 6 months. That's the only modification that they can make, and they can only do it if you've received a limited warranty. Let me do some more prohibitions under MagMoss. Deceptive or misleading warranty terms are not allowed. They can't say something that turns out to not be true, and they can't say something that misleads you into thinking that X is covered and really X is not covered. It has to be clear what's covered. Another thing that's prohibited under MagMoss are what's called tie-in sales. Let me explain what a tie-in sale is. I recently bought a Hewlett-Packard printer, and the printer was pretty cheap. It was maybe $200. It's color, it seems great. I didn't understand why it was so cheap. Well, some of you are probably laughing because this has happened to you. When you went to buy toner for the product, you realized that the Hewlett Packard toner is hundreds of dollars. So while the printer was cheap, the toner that you need to make the printer work is extremely expensive if you buy the HP brand. But you also probably found out that if you buy the Amazon brand or an off brand, it's a lot cheaper, like, a third of the price, and it seems to work fine. I use an off-brand in my Hewlett Packard printer. It seems to work fine. Now, many manufacturers will say to you, your warranty is no longer good because you used a product other than HP to refill your printer. And of course, this can go to for any product. This does not just apply to a printer. A manufacturer or seller cannot require you to buy a certain other product in order to have the warranty apply to the product that you already bought. So they can't say, if you don't use HP toner, your warranty is voided. No, that's against the law. They're not allowed to do it. Uh, One of the other things that manufacturers often do, I know that this has happened to me with certain electronics. If you try to fix an electronic device yourself, like a DVD player, and you open the back and you open it up to see what's going on, a lot of manufacturers will try to tell you that because you broke the seal or opened the product, that you have voided your warranty. Not allowed under federal warranty law. And that applies here in California. Federal warranty law applies in California. They're not allowed to say you broke the seal, warranty doesn't apply. You buy the product, that warranty applies. And here's the thing that most people are surprised about. They're not, they can't void your warranty because you didn't send in the warranty registration card. It's nonsense. It's not required. The only good thing about a warranty registration card is if you later lose the receipt to the product, sending in a warranty card is one of the ways you can prove around the time that you bought the product. So unless you're a person that is worried about losing the receipt, there's no reason to fill in that warranty registration card. They cannot void your warranty because you neglected to send it in. Even if they say so, it's against the law. So what are the remedies under MagMoss? That's really what we're all here for, to find out the remedies. So of course, you can sue for damages. You can ask the manufacturer or the seller to fix it or to repair or replace, just like under lemon law. Um, Again, just like under lemon law, the manufacturer or seller may require you to use arbitration or some other kind of informal dispute resolution. But again, you don't have to, you are not required to pay for that arbitration, and the decision of that arbitrator is not final. If you don't like the decision, you can still go to court. So it's really just a step that you have to do. Look, you never know. The arbitrator might give you a result that's good for you, and you just put it away and get your money back or get a new product, and that's it. But the arbitrator might not give you everything that you want, and you might be willing to then file a lawsuit and see if you can get the relief that you really want. And even if the arbitrator decided against you, you can go ahead and file a lawsuit in court. So, just like under the lemon law, I'm going to talk about how to enforce your rights under MagMoss. So, of course, step one, just like step one under lemon law, is make sure that your product is covered. It must be a consumer product. It must be sold with a warranty. It doesn't matter if it's new or used. If it's sold with a warranty, it's enforceable under MagMoss. The warranty must have been provided by the warranty or the manufacturer or the retailer. But if you purchased a warranty by a third party, the MagMoss enforces that warranty against that third party. So if you purchased a warranty, that warranty is enforceable under MagMoss. It depends on who you're going to force it against. I don't want to get you confused by what I wrote here, that the warranty must have been provided by the manufacturer or the retailer. It also can apply, MagMoss also applies if you purchase a warranty by a third party. It's just that you then sue the third party, not the manufacturer or the retailer. And of course, the product must have a defect that the warranty covers. So, for example, if you purchase a car and the car has a warranty and the warranty says, we do not warrant tires here. You know, this warranty covers everything in your car except for the tires and except for the windows. And you end up with a broken tire, a broken window and a flat tire. The warranty, the MagMoss is not going to help you enforce that because the warranty didn't cover that to begin with. So it must be a defect that is covered by the warranty, just like under the lemon law. So step two, you want to give them an opportunity to repair it, or you want to participate in their arbitration. You'll find this out when you contact the manufacturer or the seller to say, hey, look, I've got a defective product and I want you to fix it. And they might come back to you to say, you have to participate in this arbitration, or you have to bring it to this repair facility, and we're going to try and fix it before we decide whether or not we're going to refund or replace your product. So that's really similar to step two. You want to give the manufacturer or the seller an opportunity to cure the problem. So here, I just explained this without having it on the screen. You want to contact how to give the seller or the manufacturer an opportunity to cure. You contact them in writing, you request repair, replacement, or refund. And of course, you're going to keep detailed records of all of your communications, because if you do need to sue them, that's the kind of evidence that you're going to need. So step three, just like under lemon law, if the defect is not cured after you give them an opportunity to cure, and if the arbitration did not come out the way you want it, or if they don't require an arbitration, you're going to send a formal demand letter to the warrantor. And when I say warrantor, I mean either the seller or the manufacturer or the third party. Whoever gave you or sold you the warranty is who I'm calling the warrantor. And that's the person that you're going to try to enforce MagMoss against. So just like under lemon law, we have template letters that have those little yellow fill in the blanks. You're going to fill in all of those blanks. You're going to send the document certified, return receipt requested. That requires a trip to the post office. They're going to ask you to fill out one little green card and one little green receipt. And when you receive that green card back, it should be signed by whomever you sent that letter to. And you want to keep that you want to keep that little green card to prove that the seller or the manufacturer or the third-party warrantor received your formal demand letter. So that's a really important part of enforcing your rights under both lemon law and MagMoss. So again, you're going to give them a reasonable amount of time to either decide whether to repair or replace your product. 30 days is reasonable, and you just fill in the blanks on our templates, just like you did under lemon law. So just like under lemon law, if you don't receive a refund or replacement, you may have to file a lawsuit. Now, you can go to state court in California. That would be the courts in your county. They're called superior courts here in California, the trial level court. So you can go and bring a claim under both the California lemon law and the federal MagMoss Act. You only have to bring one lawsuit. You don't have to bring multiple lawsuits. You can bring both of these claims in one lawsuit. So usually what we recommend is that you take all the template letters and you send a lemon law demand letter to the seller and the manufacturer, and you also send a MagMoss demand letter to the seller or the manufacturer. You could certainly do those all at the same time, and if you don't receive a response that satisfies you, then you could file one lawsuit that alleges violation of both California's lemon law and the MagMoss Federal Warranty Act. Most MagMoss claims are brought in state court, even though it's a federal law. The reasons for that are beyond the scope of this presentation, but take my word for it. The only MagMoss claims that are usually brought in federal court are nationwide class actions. And that's not what we're talking about here. We're talking about us enforcing our rights with respect to a product against a seller or a manufacturer. So here are the jurisdictional limits I talked a little bit about before. So you can go to small claims court for claims up to $12,500. Attorneys are not allowed in small claims court, so you don't not only do you not need an attorney, but you can't bring an attorney into small claims court. They are made for consumers to assert their rights. It's not something that you should be afraid of. It's something that you should know how to do. It's a great way to enforce your rights, not just under warranty law, but under all different types of law. If your claim is over $12,500 or you have an attorney involved, you're going to want to file it in superior court. And there's two versions of superior court. There's limited superior, which is for claims that go up to $35,000, and there's unlimited superior, which is for claims that are over $35,000. So depending on how much your product cost and what your damages are, you would choose either civil limited or civil unlimited, and you can have attorneys in both of those parts of the court. All of these are covered by the Superior Court's self-help section, including information on small claims. So make sure you check out the county court where you live, the Superior Court section self-help. In Orange County, that's occourts.gov, and then you click on the little tab that says self-help. It's really excellent. They do a really good job of walking you through the steps you need to take to bring a lawsuit. And just like under the lemon law, if you bring a successful lawsuit under MagMoss, you are likely going to receive money to refund what you paid for the product and whatever expenses you had in trying to get your warranty rights enforced, including attorney's fees and all the other costs. So that's why, as I said before, you may be able to get an attorney to help you with a product defect, a warranty claim. So here's just a few tips that I want to leave you with. you should read your warranty terms before purchase, especially if you're buying a higher ticket item. If you're only buying an item worth $100, you might not want to take the time to read the warranty terms. But if you're buying $1,000 cell phone or a ten or $15,000 car, you want to make sure you're reading the warranty terms before the purchase, because if you're expecting that the manufacturer is going to warranty your product for, let's say, 30 days, you want to make sure that it says that in the warranty. You don't want to be disappointed and find out after you've already spent the money and taken the product home that there's no warranty coverage, or the warranty coverage is limited to a very short amount of time. You should keep all your receipts. You should keep all your repair records. I also keep the actual warranties that come with a product when I buy it. Certainly not every product, but any product that's over 50 or $100 or so, I just pull out the little plastic bag that has the warranty in it and I throw it in a file in my desk. And I never look at it again unless something happens to the product. And then I know that I've got a copy, that I've got the actual warranty, not a copy of it. A lot of times you can find a copy of the warranty online, but it's better if you have the warranty that came with the product that you purchased, because then there's no doubt that you bring in a product, you bring a written warranty that came with the product. It's pretty clear that you purchased the product and that warranty covers it. Um, After a few years, I just throw out that whole file and start again. It's not a big deal. So you should also beware of time limits on warranties, because if you start having product problems with a product at the 29-day mark, boy, it would be terrible if your warranty expired at 30 and you waited until day 31 to bring a claim. You don't want to lose your rights under warranties. I know everyone has heard stories about things breaking down the day after the warranty expires. I mean, those are really anecdotal claims. I'm not so sure that that really happens, but it's happened to me a few times. It's certainly not that the product is designed to only last for the period of the warranty. But it does seem to sometimes happen that as soon as the warranty runs out, something happens with the product, and then you no longer are covered by warranty. So you just want to act quickly when you're facing a defective product, so that whatever warranty rights you have are still applicable to that product and you can still enforce them. So now I'm just going to ask another time whether anybody has any questions. I'm going to check the Q&A. Boy, that translation does not look great. Anyway, I don't see any questions under the Q&A. So if you have any questions after this presentation, please feel free to write to us again, cww@publiclawcenter.org. You can also send us an email if you'd like us to send you a copy of the presentation or a copy of the templates so that you can go ahead and enforce your warranty rights. And we'd like to thank both Public Law Center and the Rose Foundation for supporting us in bringing this presentation on consumer warranty claims. Thank you so much for participating. Please spread the word. We're happy to have people come and watch this presentation for free. And thanks a lot for coming. Bye-bye.